I have been a defense investigator for 26 years. I have sat in more courtrooms than most attorneys, and I have watched more testimony collapse under cross-examination than I can count. I know what it looks like when a lie begins to sweat. I know the particular stillness that falls over a gallery when a jury starts to understand what is actually happening in front of them. I was not hired on the Darnell Okafor case. I was there as a favor to a colleague who asked me to sit in the back and take notes during the cross because she was managing two other matters that week and wanted a second set of eyes on Officer Tremayne's testimony. That was how I happened to be in Courtroom 3F on a Thursday morning in late October when Judge Crawford quietly took a courtroom apart. Darnell Okafor was 29 years old. He had worked the night shift at a freight and distribution warehouse on the eastern side of the city for 6 years, loading and unloading containers, running forklifts, signing intake manifests. He had no prior record. He had a daughter named Imani who was 7, and he coached her weekend soccer team on Saturday mornings, which was documented because 3 other parents had submitted character letters to the court. The charge against him was felony assault on a law enforcement officer arising from a traffic stop on the night of April 9th on Route 7 near the warehouse district. Officer Carl Tremayne, 8 years on the force, had filed the arrest report. The report stated that Okafor had exited his vehicle without instruction, advanced on Tremayne in an aggressive manner, struck the officer in the chest with an open hand, and had to be subdued and cuffed. Tremayne's testimony on the stand, delivered 2 days earlier, had matched the report almost word for word. He was calm. He was precise. He had the practiced authority of a man who had testified many times and knew how the room worked. Darnell Okafor sat at the defense table in a dark blue button-down shirt. He had told his attorney, my colleague, Priya Suresh, that he had done nothing of the kind. He had stopped at a red light. He had been pulled over on a pretextual basis. Tremayne had cited a cracked tail lens that Okafor had already filed for repair at the DMV, and had followed every instruction he was given. He had not exited the vehicle. He had not advanced on anyone. He had placed both hands on the steering wheel and kept them there, because he was 29 years old and black, and he understood what that moment required. Priya had one advantage she had not yet played. The warehouse district sits inside a web of commercial and municipal infrastructure that most people do not think about. There are traffic monitoring cameras at intersections managed by the city's transportation department. There are private security cameras on the corners of commercial properties, warehouses, loading docks, a cold storage facility 200 meters from where the stop occurred. And in April of that year, a regional freight company had recently installed a new overhead perimeter system on a span of fencing that happened to face Route 7 directly. The stop had occurred at 11:47 p.m. At that hour, the district is quiet. The fencing camera had a clean line of sight to the shoulder of the road where Tremayne's cruiser had pulled Okafor's vehicle over. The footage existed. It had been subpoenaed. The prosecution had received it in discovery. It had been reviewed, and then, in the language of prosecutorial oversight, characterized as inconclusive and not entered into evidence. Priya had entered it into evidence on Tuesday. It was Exhibit 14. I took my seat in the third row of the gallery at 8:55 on Thursday morning. Courtroom 3F is a mid-sized room, dark wood paneling, 4 rows of gallery benches, the bench elevated at the front on a platform of pale limestone. Judge Crawford was already at the bench when I arrived, reviewing something in a folder. She is a compact woman in her late 50s, with close-cropped silver hair and the precise, economical manner of someone who has learned that every unnecessary word in a courtroom is a tax on everyone's time. She had presided over Courtroom 3F for 11 years. She was not a dramatic judge. She did not perform. She ran proceedings with a clockmaker's patience, and when she needed to be still, she was completely still. Tremayne was recalled to the stand at 9:03. Priya approached the lectern with a legal pad and a remote for the courtroom's display screen. She established the basics first. Tremayne's years of service, his training, the night of April 9th, the sequence of the stop as he had described it in direct examination. Tremayne answered everything in the same measured, authoritative register. He had been on the stand before. He was not nervous. He sat with his hands clasped loosely in his lap and spoke in complete, composed sentences. Then Priya said, "Officer Tremayne, you testified on Tuesday that Mr. Okafor exited his vehicle without instruction. Is that correct?" "That's correct." "And you stated that he advanced towards you in what you characterized as an aggressive manner." "Yes." You were standing at the rear driver's side of the vehicle at that point? I was, and Mr. Okafor's door was on the driver's side. Correct. So when he exited, he would have been within arm's reach of you almost immediately. Within a few feet, yes. Priya nodded. She clicked the remote. Exhibit 14 came up on the screen. A still frame, timestamp 23:47:31, from the perimeter camera on Route 7. The frame showed Tremayne's cruiser pulled up behind a dark-colored sedan, both vehicles on the shoulder. The overhead angle was clean. The lighting was the washed amber of the district's sodium vapor street lamps, and the footage was in color. Both vehicles were clearly visible. So were the two men, one in uniform beside the cruiser, one inside the driver's seat of the sedan, visible through the rear window. Officer Tremayne, Priya said, I'm showing you what's already been entered into evidence as Exhibit 14, a still frame at timestamp 23:47:31. Do you see Mr. Okafor's vehicle? I see a vehicle, yes, and the figure seated inside the driver's seat. Can you tell the court whether that person appears to be inside the vehicle or outside it at this timestamp? A pause. The first pause of the morning. It appears to be inside. Time at 23:47:31. You testified that Mr. Okafor exited the vehicle and advanced on you. At what time did that occur, in your recollection? The stop began at approximately 11:47, within a minute or two of the initial stop. So by 11:47:31, you believe Mr. Okafor had already exited the vehicle? The exact timestamp. I don't recall the exact. I understand. Let me show you the next frame, she clicked. 23:47:44. Okafor still in the vehicle, both hands visible on the steering wheel, caught clearly in the ambient light, and the cruiser's forward-facing dash lamp. The angle of the perimeter camera meant you could see through both the rear window and partially through the side glass. His hands were on the wheel. He had not moved. 23:47:44, Priya said. 13 seconds later, Mr. Okafor appears to be seated with his hands on the steering wheel. Is that consistent with your account of events? In the gallery, I watched two of the jurors lean very slightly forward. Juror 4, a retired postal worker in a gray cardigan, turned her head a fraction toward Juror 7. That is the moment. When jurors start exchanging glances, the tide has already shifted and they do not know it yet. The camera angle may not show, Tremayne began. The footage is already in evidence, Priya said. The court has it. Let me show you one more frame. 23:48:19. Okafor's door opening. Not aggressively, the door swings at the measured pace of a man complying with an instruction, and the timestamp was 23:48:19. A full 48 seconds after the moment Tremayne had described as the point of the alleged assault. I saw Judge Crawford's pen stop moving. Officer Tremayne, Priya said, you testified that Mr. Okafor struck you in the chest with an open hand. Was this before or after he exited the vehicle? After he exited. After 23:48:19 then. After this frame. If that's when the door opened, it's Exhibit 14. Prosecution received it in discovery. It was characterized as inconclusive. Priya set the remote down on the lectern with a quiet click. The door opens at 23:48:19. The alleged assault, by your own testimony, occurred after Mr. Okafor exited the vehicle. The footage runs for another 4 minutes and 12 seconds. I'd like to play it. The prosecutor was already on his feet with an objection. Judge Crawford raised one hand, not sharply, just raised it palm flat, a traffic gesture, and the prosecutor stopped. Overruled, she said. The footage is in evidence. Play it. Priya played it. 4 minutes and 12 seconds. In that footage, Darnell Okafor exited his vehicle slowly, with both hands visible, stepped to the rear of the car as instructed, placed his hands behind his back, and was handcuffed. At no point did he advance on Tremayne. At no point did he raise either hand. At no point did any contact of any kind occur between his palm and the officer's chest. The footage was unambiguous. The lighting was sufficient. The angle was sufficient. And the timestamp ran continuously in the corner of the screen the entire time, visible to everyone in the room. The courtroom was very quiet when it finished. Priya turned to the bench. Your Honor, I have no further questions for this witness. Judge Crawford looked at Tremayne for a long moment. She did not speak immediately. In 11 years of watching her work, I had seen her use silence as a tool before, not dramatically, not for effect, but with the quiet precision of someone measuring weight. The witness may step down, she said. I'd like to address the matter of the exhibit's prior characterization as inconclusive before we proceed. What followed was not heated. Judge Crawford did not raise her voice. She asked the prosecutor to approach the bench, and the exchange that occurred there was low and measured and lasted approximately 3 minutes. Could not hear the substance of it from the third row, but I could see the prosecutor's posture shift. When he returned to his table, he sat down with the careful deliberateness of a man who knows the room has changed and is deciding how to proceed. The jury was excused for the morning recess. At 11:41, after a 90-minute recess, during which I drank 2 cups of coffee in the courthouse cafeteria and watched Priya pace the second-floor corridor with her phone pressed to her ear, court reconvened. The prosecutor stood and moved to dismiss all charges against Darnell Okafor on the grounds that the evidence no longer supported the charge beyond a reasonable doubt. Judge Crawford accepted the motion. She said 4 additional sentences from the bench, sentences I wrote down verbatim in my notes because I thought I would want them later. This court notes that the footage entered as Exhibit 14 was produced in discovery and was characterized in the prosecution's internal review as inconclusive. The court does not find it inconclusive. The court also notes that Officer Tremayne's sworn testimony, given under oath on Tuesday, is materially inconsistent with the documentary record. This matter is dismissed with prejudice, and a referral for review of Officer Tremayne's testimony will be forwarded to the appropriate oversight body this afternoon. She set down her pen. Mr. Okafor, you are free to go. Darnell Okafor stood at the defense table. He didn't say anything for a moment. He pressed both hands flat on the tabletop, took one breath, and nodded once. His attorney put a hand briefly on his shoulder. I walked out of courtroom 3F into the corridor and stood near the window at the end of the hall that looked out over the courthouse parking lot. The trees along the perimeter had turned. It was a bright October morning, and the light was clean and hard, and everything outside was very still. I have been doing this work for 26 years. I have sat in more courtrooms than most attorneys. I know what it looks like when a lie begins to sweat. The first pause, the fractional shift in posture, the moment a juror leans toward the person next to them. I know the specific quality of a courtroom that has understood something and the particular kind of quiet that follows when a judge speaks 4 sentences and stops. I called my colleague. She answered on the first ring. Did you see it? She said. I was there, I said. You built the record right. She was quiet for a moment. Then she said, his daughter plays soccer on Saturdays. I know, I said. I read the character letters. Darnell Okafor walked out of the courthouse at 12:04. He stood on the front steps in the October light and looked out at the parking lot for a moment, like a man reminding himself what the open air feels like. His sister was there. She had come to the gallery that morning, and she was waiting for him on the steps. She said something I couldn't hear. He put both arms around her and held on for a long time. I did not intrude on that. I walked to my car, drove back to my office, and wrote up my notes. On the last page, I wrote the 4 sentences Judge Crawford had said from the bench, the same way I had written them in the courtroom, verbatim, not because anyone had asked me to, because I thought they deserved to be kept somewhere.